Ms. Reader, apparently your camera is still off. And Mr. Reinhardt, we do see you, so bear with us a moment.
There you are.
There, Ms. Reader. All right, so we are all in the virtual courtroom. So as I said, Sasser versus the commission. Mr. Reinhardt, we're ready to hear you.
Good morning, may it please the court. I represent the appellant.
Mr. Reinhardt, you may need to pull yourself closer. We're not getting all the sound on the microphone.
All right, how's that, Judge? Is that better?
You're gonna probably need to speak up louder or get even closer.
Is your mic maxed out?
That's what I'm trying to see right now. I believe it was, but let's see. Real fast. Audio settings. It is now. Is that any better?
Yes, sir. Thank you.
Reinhardt.
All right. Yes, sir. I represent Luther and Sherry Sasser. They're the claimants in this forfeiture action. I'd like to reserve 5 minutes if I could for rebuttal.
Very good, thank you.
The subject property herein is a boat, motor, and trailer taken by the agency, Florida Wildlife Commission, back on April 30th, 2015. The issue is after they filed a petition for forfeiture some 30 months after the seizure of the vessel, we did file a motion to dismiss, raising constitutional grounds, the same issues that was raised previously in general forfeiture proceedings with Department of Law Enforcement versus Real Property, Supreme Court's decision from 2001, 1999. And then predecessor statute in this, where the Third District Court of Appeals found that procedural due process that was equal to what the Florida Supreme Court had said in Real Property versus action would apply to a marine seizure on the predecessor statute of this statute.
Mr. Reinhardt, I have a procedural question, please. I saw that a motion to return property was filed in November of 2015, and there's an indication there may or may not have been a hearing on December 8, 2015. Was there a hearing on that motion?
There was, and the trial judge punted. FWC, the agency, was served. They did not attend. They did not answer the motion. It was before the criminal court on the criminal proceedings against a third party, not my clients, Mr. Wade, who had possession of the subject property on the issue in question, the night in question. And so the trial court punted. We then filed a second motion for return of property, May 9th, 2016. Served on FWC. FWC did not respond, did not attend a hearing, and the trial court once again punted. I think the problem with the trial court is that, well, you have criminal proceedings ongoing, and so the trial court didn't make a determination whether or not the subject property should have been held as evidentiary purposes in the criminal case, and so that's why nothing was ever resolved with the trial court. Essentially, the agency did provide a notice to the Sassers, my clients, shortly after the seizure of the property, but we believe that the notice was wholly insufficient to provide due process. So our position is that the statute in question must comply. In order to comply with due process, in order to be read constitutional, it has to have the same procedures as the Florida Supreme Court set forth in the Real Property case and the Third District Court of Appeals set forth in the Valdez case. I'll grant you that those decisions were not based on this particular statute, but this statute has the same constitutional flaws that those statutes do.
Mr. Reinhardt, I know you really want to get into the constitutional argument on this. I hate to throw you off track, so I'll try to be quick on this, but I just want to make sure I understand the record and kind of what's played out here. So as I see it, you actually filed a motion on January 23rd, 2018 to have section 379.337 declared unconstitutional. Whatever happened to that motion?
It was not heard by the trial court.
Okay. And I also couldn't help but note that the judgment that is presently before us says it was agreed to, and certainly FWC, they make that argument, at least in their answer brief, that hey, this was stipulated to. but I see references in the record that, that apparently there were some discovery disputes, and at least in one of FWC's summary judgment motions, they throw a footnote in there that Mr. Sasser's interest in the boat may have been foreclosed by virtue of him being defaulted basically as discovery sanctions. Can you help me fill in the blanks here? Help me out with this record. What happened?
This is what happened. The boat was taken on in 2015, in April of 2015.
Right.
After the boat was taken, Mr. Wade was prosecuted. In the long run, he pleads to credit for time served, no other sanctions on a felony of failure to properly transport the net. That was 60 pages or so of the record. The rest of the record is FWC's voluminous, in my opinion, abusive litigation of this forfeiture action. So
I get it. There's people are hot under the collar about discovery in this. That came through loud and clear. Can you I want to keep you focused on that point though. Just tell me what happened. Did he get defaulted?
What happened, Judge, is that we did the motion to dismiss, raising constitutional grounds. It was denied by the trial court.
Well, wait. Was that motion heard?
Yes, that motion to dismiss was heard by the trial court.
Okay, the motion to dismiss was heard, but not the motion to determine constitutionality.
Correct, but the motion to dismiss raises the constitutionality of the statute and the due process requirements of the statute.
It does address it. Yes, it does address it.
Okay, so then in the long run, with all the voluminous discoveries, at some point in time, Mr. Sasser said no. So the judge defaulted him on the failure to provide discovery. We go along, it's just constant from FWC's. So finally we told the trial court, look, we want to appeal the denial of the motion to dismiss. We didn't do it preliminary. We don't think that was a procedural impediment to us to appealing a final judgment. The court entered a final judgment and this appeal goes forth. That's where we are. If you knew a little bit more about the history of it, that was outside this.
No, I don't want to know anything. I can't speak for my colleagues, but I can tell you, my question should not have been interpreted as a request to go outside the record. Just help me connect, because there's gaps in the record and parts seem to talk to other parts. And I just wanted you to help me connect what I'm trying to connect from what I'm seeing in it.
I've got it. I don't believe the fact that there was other stuff done in the forfeiture proceeding precludes us from raising the issue of was it proper to deny the motion to dismiss. It should have been granted by the trial court. And so that's where we are. And this is a de novo review by this court. It's clear that this statute that they're operating under does not comport with the due process requirements for a forfeiture case.
Let me interrupt you there, Ms. Reinhart, because there are a couple of procedural aspects to this case that seem to reflect due process was provided to your client. After the seizure was accomplished, there's no dispute that a notice was sent and received by your clients, correct?
That's correct.
And that was within a couple days of the seizure.
That's correct.
And your clients filed a motion for return of the property?
Yes, sir.
And there were 2 hearings apparently that took place, but a final hearing or a final determination was not reached. Is that part right?
That's correct. They were, before the criminal court on Mr. Wade's prosecution, and the trial court did not make a determination on the motions for release of property.
Then subsequently, the criminal case is resolved, and within the time period set out in the statute, a motion for forfeiture or a request for forfeiture was filed by the commission. Is that correct?
About 10 months after the criminal case was resolved, Judge Silverman. I don't believe the statute contemplates waiting 10 months to seek forfeiture against somebody.
And that might be a laches argument. There might be some other arguments that could be raised, but in terms of the wording of the statute, unlike the statute that talks about notice, which I don't have it in front of me, but I think it was 14 days, 10 days, 14 days, somewhere in there. And that part was complied with. Now, the forfeiture part of the case, as you said, it was months after the criminal conviction, right?
Yes, sir. It was after the criminal convictions. That's what the court was asking.
What happened in response to that forfeiture action?
I'm sorry, you broke up there a little bit, Judge Silverman.
What happened after they filed the motion for forfeiture? What happened?
Okay, so the petition for forfeiture is filed. We filed a motion to dismiss shortly thereafter, and then the case proceeds through the forfeiture proceeding.
So what do at this point, and honestly, I had some trouble deciphering it from your brief. What due process aspects do you say at this point were not complied with in a manner that was detrimental to your clients?
Okay, first of all, I don't believe that their notice complies with due process requirements set forth by the courts. Again, I think that what they have to do in order to comply with procedural due process is that the agency has to either apply for an order, pre-seizure order from a trial court, of finding a probable cause. That wasn't done in this case. Or since it's personal property, they could simply seize the property and then provide notice to the property owners and lien holders that the property has been seized and that they have a right to request an adversarial preliminary hearing. And if the adversarial preliminary hearing is requested, could do it within 10 days. It's not the claimant's responsibility to comply with due process. It's the agency's. They have the burden of doing that. If the claimants don't scream loudly enough, or we simply to ignore the agency's completely violating someone's due process rights, I think that's ridiculous. If the agency illegally seizes a piece of property, which is clear in this case, they had no lawful grounds to seize this property, then until they get caught, there's no harm, no foul. It is patently ridiculous. So they don't advise them that they can seek an adversarial preliminary hearing. They don't advise them they can seek that from a court. They simply say, hey, if you're innocent, tell us why you're innocent, and we'll have a hearing on it. That doesn't comply with due process. So they don't seek a pre-seizure order from the trial court. When they notify the appellants, the claimants, they don't tell them that you can have an adversarial preliminary hearing within 10 days. No such hearing is held in 10 days. The notice basically puts the burden of proof on the claimants instead of the agency. The notice essentially tells them, prove your innocence. It doesn't say anything about we have to prove the case by clear and convincing evidence. And it's certainly—
Mr. Reinhart,
Yes.
Where in the record could I find Sherry Sasser's precise interest in this property?
We're in, I believe in the petition for forfeiture, it shows the title to the property, the boat, and it has her listed as a lien holder.
As a lien holder. Okay.
Yes.
Because if I take your appeal on its face, you don't really raise an argument against the default. I mean, at least I didn't see one. Maybe I missed it. About Mr. Sasser's default on May 7, 2018, where his answer is stricken and the forfeiture is basically deemed done as to him.
I got that the answer is stricken, Judge Lucas, but the motion to dismiss is not stricken. It was raised by Mr. Sasser from the very beginning. I don't believe that his being defaulted.
Here's what it says, counsel. Luther H. Sasser III's defense to forfeiture in this matter is hereby defaulted in favor of commission.
I've got that, but I don't believe that that language means that the agency's violation of his due process rights on procedural grounds and his motion to dismiss there, it can't be considered by the appellate court. I don't take it to read that.
Without challenging that default, you think you get to bypass that little detail? Because it's kind of important, right? A default where you get your answer stricken, where you get, where it says your defense is done, defaulted in favor of the commission. I mean, that's an important detail.
Okay, Judge Lucas, I understand that, and I don't have a disagreement with you concerning the answer in the defenses and generally speaking. But a motion to dismiss is not, I guess if you want to try to say it's a defense, perhaps the rules of civil procedure may refer to as defenses and stuff, but I don't believe that that default order strikes his defense against the, prosecution of this forfeiture from jump as unconstitutional as applied to him. That's my position on it. I don't know that there's any case that says, hey, you got defaulted, so now you can't even raise the fact that you were denied procedural due process from day one.
Under the rules of civil procedure, a default is considered an admission as to all facts except in contested cases about damages when you're talking, but this is forfeiture of real property, so I'm not even sure that would apply. I mean, I'm having a hard, you didn't appeal this. You did, or at least you didn't raise the argument. So I'm not sure what I'm supposed to do with it. And all we're left with now is, well, Ms. Sasser, according to the petition, is a lien holder. And so as such, she's asserting this due process concern that you're raising as a lien holder. Just, you know.
Okay, Judge Lucas, I don't see in the appellee's brief that they say he's been defaulted and therefore he can't raise the issue that he's raised.
Well, they do say it was an agreed judgment. Now, whether or not it was truly agreed as opposed to a judgment that was entered as by virtue of a sanction, I mean, you can quit, but I mean I have not read in your briefs where you challenged the statement of the judgment that it was agreed. I have not read in your briefs, even though you had an opportunity for reply, where you say, you know what, no, this wasn't agreed, or this wasn't, or, you know, help me out with that. Or is it just you really want a ruling on due process?
No, I'm the trial attorney. When you have the final judgment agreed to, I guarantee you in court, we stated, we all understand, both parties, and Ms. Rita was there too, if she wants to argue with that. Both parties agreed that what we were raising was the proprietary of the motion to dismiss and whether the case should have been dismissed on constitutional procedural due process grounds.
Yeah, but my question, sir, is the agreed final default judgment states that your clients were served process, and then it also cites the statute that there was established a sufficient showing that the property was used and intended to be used in violation of the saltwater products offense. So rather than appealing a final judgment based on the ruling of their motion your motion to dismiss, rather than appealing a final judgment based on the ruling on the motion to dismiss, you've appealed an agreed final judgment that makes findings showing that the FWC has fulfilled has complied with the statute. That's what we're trying to understand here.
I don't believe the final judgment, agreed final judgment, states that they've complied with the procedural process.
It says your clients were served with process, and you're sitting here and disagreeing with us right now when the order says they were.
Judge Sleeve, to serve with process means you're served with the petition for forfeiture. We didn't agree that they were properly noticed of this action and that procedural due process was complied with. It's the objection that we raised the entire time with the trial court.
This order doesn't say that you disagree. This order doesn't say what you just said.
Mr. Reinhardt.
I don't believe it's what you say it does, Judge Sleeve. I'm sorry. Yes, sir, Judge.
If you want to reserve your 5 minutes, I've let you go over. I know Judge Sleet and Judge Lucas, if they have any more questions, certainly they can ask them, but otherwise you're now in the 5-minute break.
Thank you.
Ms. Reeder?
May it please the court. Good morning. My name is Jessica Reeder, and I represent the Florida Fish and Wildlife Conservation Commission. Judgments are presumed correct, and this court may affirm on any basis supported in the record. Florida courts have held that when parties enter into stipulations and never specifically seek relief from those stipulations, that any due process argument after the entry of that stipulation is waived. And that's exactly what happened here, Your Honors. In the lower court, both appellants, they not only requested a default judgment in favor of the commission, but they agreed upon a final default judgment in favor of the commission. And because they requested it, because they agreed to it, the commission's position is that any due process argument here at the appellate level is waived. And unless the courts have any specific—
Is it clear from the record that the agreement was with the intent of being able to appeal the dismissal or denial of the motion?
It's without going into other conversations that happened at the hearing, Your Honor.
The record. I mean, my recollection is I don't remember if it was a transcript or it was a pleading, but I thought there was some recognition that the agreement was going to be, the agreement for the final judgment was in order to appeal the denial of the motion to dismiss.
Yes, Your Honor, that was in the initial pleading from the appellants. The request to have that language in the final agreed upon order, and that language is missing from the agreed upon default judgment that was actually entered by the court.
So is it your position that it was not understood based on this record, that it was not understood that they wanted to get review on appeal of the denial of the motion to dismiss?
Based on the record, Your Honor, the commission's position is that is what appellants requested, and that was not agreed upon, and that was not the final entry.
Go ahead.
And unless your honors specifically have questions regarding the due process arguments presented by appellants in their briefs, we would request that you affirm the default entry that was requested and agreed upon that was entered by the trial court.
Was a stipulation filed in the record? I mean, you just argued that the parties stipulated to the agreed final judgment. I don't see that in the record.
What I was referring to, Your Honor, is the agreed default judgment in favor of the commission, which is the final order that was entered on the record page 682 to 683.
Very good. Thank you, Ms. Reeder. Mr. Reinhardt, you've got 5 minutes, but I'd like you to address my question as well, because I thought when I read the record that there was some indication that the agreed upon judgment was it was agreed upon so that your client could seek appellate review of the denial of the motion to dismiss.
Exactly what happened, Judge.
Hang on. Is it reflected in the record, or was I just interpreting that?
I don't know that the transcript is in the record. We had a transcript. We had a hearing before the trial judge, Judge Aaron, who took over the criminal bench. And Ms. Reeder was there, I was there, and we asked the court.
Okay,
and
well, the transcript's not there. There's no stipulated statement as to what occurred. For some reason, I thought I saw something indicating that, but it may have been more my interpretation of what was there rather than what was actually stated. So I don't want to use up all your time on that unless there's something you can point to. Go ahead with your rebuttal.
Right now, off the top of my head, I can't point to something. I just feel like we're down the rabbit hole. You know, the agency comes in, they take a vote with no legal authority to take the vote. Search warrant doesn't let them take the vote. The statute doesn't let them take the vote. They hold the vote for a long time. That, you know, 10 months, a notice that doesn't comply with any form of due process to the claimants. And then they argue, well, the claimants didn't scream loudly enough or are illegally taking the vote. It's ridiculous. These are just working class. This is a working class fisherman and, you know, his mother who has a lien on the boat. Boat's not, you know, a $1 million vessel. It's a fishing boat. And they hold it for 30-something months.
I'm curious about your righteous indignation here, because your clients filed a motion for return very early in this case, and then they didn't pursue it to conclusion. So I'm a little skeptical of the righteous indignation that you're sharing with us.
I'm sorry, but what else is he supposed to do? He files a motion, the trial court punts it because it's in criminal court. He files a second motion, the trial court punts it since it's in criminal court. He's not, some other guy is. Is he supposed to track exactly what's going on with that criminal case? The criminal case gets over. 10 months later, that he's being told, hey, we're going to keep your boat forever. I understand what you're saying, that maybe he should have been jumping up and down every 5 seconds, but I mean, goodness gracious. He jumped up and down. They're the ones who violated the law on every step of this daggum thing. They're the ones who haven't complied with due process requirements.
Is there a ruling in the record where the trial court declined or denied the motion for return of the property? I hear what you're saying, but there are some orders that indicate they're continued for a couple of different reasons. Was there anything where you got a ruling saying, we don't have jurisdiction to rule on this?
No, sir. The trial judge, it was brought in the criminal court because that's the only proceeding that was going on with Mr. Wade. The trial court did not rule on the motions for return of property. The trial court simply said, I'm not making a rule deferring ruling. There was no denial or order granting. Obviously, there's no order granting. There was no denial. It was just a deferral, again, because you've got a criminal prosecution going on.
But under that circumstance, I mean, that's effectively a grant, right? I mean, he has to return the property. The state is holding the property. The judge says, I'm not going to rule. He's effectively granted it.
All right, Judge, listen, I got you. So that excuses the agency's 10-month delay in trying to seek further.
I'm focusing on what what happened, what your client could have done, what your client did, what they didn't do. That's what I'm focusing on. I hear what you're saying about what the state did. I'm just saying, look, I mean, it looks to me like under that circumstance, it seems to be the trial court effectively granted, or excuse me, effectively denied the motion for return of property by virtue of saying, yeah, the state can keep holding it.
All right, well, again, if anything's done, it was done in the criminal case. There was no forfeiture decision, there was no proceeding pre-forfeiture by a, court acting in a civil forfeiture proceeding to determine whether or not they could continue to hold the property and whether it was least restrictive means to do it. None of that was complied with. It's like they're putting the burden on the claimants, the property owners, to raise all these issues. The burden is on the agency. And they have acted beyond the pale in this case, and we're simply saying, well, you didn't complain loudly enough. The statute is wholly deficient for due process requirements, and we're letting the agency get away with doing what they've been doing and basically abusing, in my opinion, the forfeiture proceeding. There's 600 and something pages compared to a 60-page criminal case on this action. It's ridiculous. And like you said, there's other stuff there that happened outside, and we're not even talking about that. At some point in time, a court has to step in and say, you know what, agency can't act against somebody's personal property in this fashion without complying with due process. It wasn't done in this case. I don't even think that any of the court here or Ms. Reeder can argue that due process was complied with. The question is, are we going to put up with it, or are we going to say, well, you didn't scream loud enough, Mr. and Mrs. Sasser, so therefore, you lose. I don't think that's right.
Very good. Thank you, counsel, for your arguments. That concludes this case. You'll be asked to leave the virtual courtroom. That also concludes the cases on the docket. So with that, we are adjourned.